She sued her own brother for $47,000 and ruined everything. She sued her own brother for $47,000, and the courtroom wasn't sure who to feel sorry for. For 12 years, the plaintiff and her brother had been close in the way that only siblings who survive something difficult together could be. Their mother had passed when they were teenagers, and the two had leaned on each other ever since. He became a physician, a respected OB/GYN in a mid-sized coastal city. She became an event planner, someone whose entire livelihood was built on the promise that important days would go exactly as intended. For a brief window of time, those two worlds collided in the worst possible way. The wedding was scheduled for a Saturday in late April. The plaintiff had been engaged for 14 months, and by her own account, every detail had been curated with obsessive care. The venue deposit alone was $8,200. The catering contract, non-refundable, ran another $14,000. The dress, the flowers, the photographer, the honeymoon suite at a resort 3 states away. All told, she had committed $47,000 in non-refundable expenses to a single day. And then, 11 days before that day, her fiancé ended the engagement. She never made it down the aisle, but that wasn't who she sued. She sued her brother. The plaintiff's argument was precise and unflinching. 8 weeks before the wedding, she had visited her brother's private practice. Not as a patient, but because he had offered to run routine blood work as a professional courtesy between family members. During that visit, she claimed he made an offhand remark about her fiancé. Specifically, she alleged he said the fiancé seemed settled and completely committed, and that she had nothing to worry about. She testified that this reassurance caused her to abandon a conversation she had been planning to have with her fiancé. A difficult reckoning about whether they were truly aligned on having children. She had been postponing it for months. After her brother's comment, she postponed it indefinitely. 11 days before the wedding, she finally had that conversation. The engagement ended the same night. Her legal theory was negligent misrepresentation. She argued that her brother, speaking in his capacity as a trusted advisor, whose professional judgment she had always deferred to, had given her a false sense of security that caused her to delay a critical decision until it was financially catastrophic to reverse course. $47,000. All of it gone. The defendant, her brother, sat at the other table looking less like a man defending himself and more like a man quietly grieving. His attorney argued the obvious. He was a physician, not a relationship counselor. He had made an ordinary human remark about his future brother-in-law's demeanor. No professional duty existed, no contract had been formed. His words were the kind of thing any sibling might say at a kitchen table, and cloaking them in legal liability was not only absurd, it was dangerous precedent for every well-meaning family member who ever offered comfort. The courtroom seemed to be leaning his way, and then the defendant's own attorney made a catastrophic error. In an attempt to establish the casual, non-professional nature of the visit, the attorney introduced the sign-in record from the brothers' practice. The very document meant to prove no formal patient relationship existed, but the sign-in sheet, time-stamped and notarized as part of the practice's standard records, showed something the defense had not anticipated. Beneath the plaintiff's name, in the visit purpose field, someone had typed 4 words: family consultation, personal advice. It was a small clerical entry. It may have meant nothing, but it gave the plaintiff's attorney exactly the foothold she needed. If the visit had been logged, even carelessly, as a consultation, even a personal one, then the professional context of their relationship was suddenly not so easy to dismiss. The judge took 3 days to deliberate. She ruled in favor of the plaintiff, but not for $47,000. After careful consideration of proportional liability and the limits of what any reasonable person could have anticipated from a single remark, the judge awarded $18,500. Specifically, the catering deposit, the photographer's retainer, and the venue fee. The items most directly tied to a window of time during which, the judge found, the plaintiff might have acted differently had she not been given a false sense of reassurance by someone whose professional judgment she demonstrably and historically trusted. The defendant paid the judgment 4 weeks later. The plaintiff accepted it without a public statement. Their relationship, by most accounts, did not survive the verdict. Mutual friends described a silence between them that felt less like anger and more like grief. The particular grief of 2 people who both feel wronged by something that might have been a misunderstanding. What no ruling could determine, and what no court could settle, was the question that lingered longest. If she had simply had the hard conversation with her fiancé when she first knew she needed to, would any of this have happened? And whose job is it really to protect us from the uncomfortable truths we already know?